In this moment, the courtroom falls completely silent. The judge begins reading the punishment: life imprisonment for count 1, life imprisonment for count 2, and 10 years for count 3. His voice is steady, but the weight of those words is heavy. This is the moment where everything becomes real. This is the moment where everything becomes real. This is the moment where everything becomes real.
Your sentences will be as follows. As to count 1, the jury having fixed the verdict at life imprisonment, this court will sentence you to life imprisonment. As to count 2, you'll be sentenced to life imprisonment. As to count 3, you'll be sentenced to 10 years to serve. You'll be required to pay court cost fees and assessments in the amount of $431.50. Ms. Gregg, regarding any appeal of your judgment and conviction and order of sentence and in accordance with...
Here, the judge explains the defendant's last legal rights, the window to appeal, the deadlines, and the rules. It's dense, technical, and serious. But what's powerful is the judge's tone: calm, direct, and final. He's making it clear that this is the last door the defendant can choose to open. Do you think the judge should give defendants more time to appeal, or are these rules fair?
Wright versus State 577, Southern 2nd 387. The court wants to inform you that pursuant to Rule 4E of the Mississippi Rules of Appellate Procedure, the notice of appeal required by Rule 3 of such rules shall be filed with the circuit clerk within 30 days after the date of the denial of any motion for a new trial, or the date of imposition of sentence, whichever is later. Pursuant to Rule 4E, if you make a timely motion under the Mississippi Rules of Criminal Procedure for a judgment of acquittal notwithstanding the verdict of the jury or for a new trial under Rule 25.1, the time for appeal shall run from the entry of the order denying such motion. Finally, Rule 25.1 subsection C provides that a motion for a new trial must be made within 10 days of entry of the judgment, which includes both adjudication of guilt and sentence. Should you make a decision on...
Then comes the most dramatic line. Have you made a decision to appeal your conviction and sentence? This question isn't small. It determines whether the fight continues or ends. And just like that, the court moves into recess, the calm before another emotional storm. If you were in the defendant's position, would you appeal or accept the verdict?
The record to appeal, that decision will stand unless a written statement to the contrary signed by you and your attorney is filed with the court. Should you make a decision to waive appeal, that decision will stand unless you give written notice to the court and your attorney prior to expiration of the time in which you perfect an appeal. Should no decision to appeal be made by you, your failure to express a desire to appeal shall be considered a waiver of your right to appeal, and that waiver will stand unless you give written notice to the court and to your attorney prior to expiration of the time in which you perfected an appeal. Have you made a decision to appeal your conviction and sentence? All right. Court will be in recess.
Your Honor, I need clarification. I apologize. On the
Sentences will run concurrent.
Now, the atmosphere changes. The jury walks in holding papers, the verdict forms. Everyone watching knows this is the moment that seals fate. The judge takes the papers, carefully checks them, and begins reading. Ever noticed how a courtroom becomes tense when verdict papers appear? You can almost feel the air shift.
You can sit right there, ma'am. Ma'am, I see you're holding some papers. The jury been able to reach a verdict in any of these counts.
yes, sir.
All right, if you would, please hand the paper to the bailiff. Ms. Gregg, please rise and come to the podium, along with your attorneys. All right, the verdicts appear to be in proper form. Verdict of the jury is count 1. We, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Count 2. We, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Count 3. We, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Please be seated, Ms. Gregg.
The judge reads the jury's decisions. guilty of first-degree murder, guilty of attempted murder, guilty of tampering with evidence. Then comes the roll call, each juror confirming the verdict out loud. It's uncomfortable, intense, and emotional. Each yes feels like a punch of reality for the defendant. Do you think reading each juror's vote out loud is necessary, or is it too harsh?
Ladies and gentlemen, the jury is custom for the court to poll the jury. I have to do it each time. And for each count, I'm not being rude. The quickest way for me to get through this is to simply point at you and you answer out loud. As to count one, we, the jury, find the defendant, Carly Gregg, guilty of first-degree murder as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? You got to answer out loud, ma'am. I'm sorry.
Yes.
On the back row, sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? That verdict is proper and unanimous. As to count two, we, the jury, find the defendant, Carly Gregg, guilty of attempted murder as charged in the indictment. Beginning on the first row, ma'am, is that your verdict?
Yes,
Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict?
Yes.
Ma'am, is that your verdict?
Yes.
On the back row, sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict?
Every verdict is declared proper and unanimous. At this point, there is no confusion, no doubt. The jury stood together in agreement. This moment is powerful because unanimity shows that the evidence was overwhelming enough for 12 different people to see the same truth. Does a unanimous verdict make you more confident in the system? Why or why not?
Count three, we, the jury, find the defendant, Carly Gregg, guilty of tampering with evidence as charged in the indictment. Beginning on the first row, ma'am, is that your verdict?
Yes,
Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict?
Yes, sir.
On the back row, sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? All right. All three verdicts appear to be unanimous. The court will enroll the verdict. All right. All right, ladies and gentlemen, with you having returned a verdict of guilty in count one and count two of the indictment, we'll now proceed to the sentencing phase of the trial. State of Mississippi may call its first witness.
Now, both sides prepare for the next stage, deciding the punishment. The state wants to include earlier testimony and a new photograph. The defense objects. Lawyers whisper, approach the bench, negotiate. It's strategy versus strategy. Every move matters. Every objection could shift the outcome. Do you think photographs should be allowed in sentencing? Can they unfairly sway emotions?
Your Honor, the state has no witnesses. We would just ask that the court adopt the previous testimony that the jurors have heard, with the exception of we seek to introduce one photograph.
All right. State wishes to move to adopt and incorporate by reference the record of the guilt phase. Is that correct?
That's correct,
Show your piece of evidence to the other side. Any objection?
Your Honor. Yes, Your Honor.
Y'all approach. All right, the state has moved to adopt and incorporate by reference the record of the guilt phase of the trial. The court will grant that request. Does the state have any other witnesses it wishes to call?
No, sir, Your Honor.
All right, defense may call any witnesses.
We don't have any witnesses, Your Honor.
All right. With the defense not calling any.
Here, the judge gives the jury very strict instructions. For the murder charge, they must choose life imprisonment or life with the possibility of parole. The judge explains factors like age, family environment, circumstances of the crime, and potential for rehabilitation. This is the emotional heart of the video, the moment where the jury must judge not just the crime, but the person. If you were on this jury, what would matter more, punishment or the possibility of rehabilitation?
Any witnesses, attorney's approach. Does the defense rest its case in chief as to sentencing?
We do, Your Honor.
Do you also move to adopt and incorporate by reference the record?
We do, Your Honor.
All right, y'all approach. All right, ladies and gentlemen of the jury, with both sides agreeing to rely on the testimony from the guilt phase, the court will further instruct you at this time. You, the jury, have found the defendant guilty of the crime of first-degree murder in count 1. You must now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury that you should consider the following factors in making your decision. 1. The defendant's chronological age. 2. The defendant's family, home, and environment. 3. The circumstances of the homicide offense. 4. The defendant's incompetencies associated with youth. And 5. The defendant's possibility of rehabilitation. The court instructs the jury that when all 12 of you reach and agree upon the defendant's sentence for first-degree murder, you shall return the sentence in one of the following forms. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections, your verdict will be as follows. Quote, count 1. Quote, as to count 1, we the jury sentence the defendant Carly Gregg to life imprisonment. Close quotes. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections with the possibility of parole, your verdict will read as follows. Quote, as to count 1, we the jury sentence the defendant Carly Gregg to life imprisonment with the possibility of parole. Close quote. If you cannot agree to the sentence for the defendant as to first-degree murder, your verdict will be as follows. Quote, as to count 1, we the jury are unable to affix the punishment. Close quote. You, the jury, have found the defendant guilty of the crime of attempted murder in count 2. You must now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury.
Professional overview. Summary of the case. In this case, Carly Gregg was found guilty on all 3 counts: first-degree murder, attempted murder, and tampering with evidence. The jury confirmed each verdict unanimously. After reviewing the evidence from the trial's guilt phase, the court moved to sentencing, where the jury must choose between life imprisonment or life with parole for the most serious charges. The judge ensured all legal procedures were followed, including detailed appellate rights. This case highlights the complexity of criminal trials, the balance between justice, procedure, and human emotion. Final CTA, call to action. If you found this breakdown helpful, don't forget to like, share, and subscribe for more courtroom commentary, real case analysis, and powerful justice system stories. Your support helps us bring more real events to light.